Attorney General Jeff Sessions calling for an investigation into the Bundy case. That's after a judge declared a mistrial, saying that federal prosecutors withheld evidence that could have helped the defense. Now, you'll recall back in 2014, the Bundy cattle ranching family got into a heavily armed standoff with federal agents, and it began with a dispute over fees for federally owned land. So let's bring in our legal panel, defense attorney Doug Burns and former prosecutor Stephen Mulroy. Nice to see you both.
Thank you.
All right, Stephen.
Thank you.
Stephen, I want to start with you. You know, the authorities say that Cliven Bundy owes about $1 million in these fees. Now there's this mistrial. Help us to understand what happened.
Well, the underlying dispute about whether he owes the fees and whether the government has the right to control what happens on federal lands, that's not really in dispute. Federal courts have twice ruled against the Bundys. But as to the criminal charges relating to whether they were involved in a conspiracy to impede a federal investigation or to assault federal officers, carrying firearms illegally, all those things, right now, we've got a mistrial. It means that there is no conviction. The trial has been called to a halt because the prosecutors acted inappropriately. They did not disclose information they were required to disclose under the rules, which could have helped the defense team make their case.
Well, Doug, prosecutors are usually really careful not to taint a case. It's why they often, go for lower convictions so that they can lower charges so they can get the conviction.
Sure.
So how unusual is it for a mistrial to be declared because of prosecutors withholding evidence?
It is unusual, and it's a prosecutor's worst nightmare. I mean, go back to 2008, the Ted Stevens case up in Alaska. The late Senator Ted Stevens, DOJ was chastised, criticized for prosecutorial misconduct, withholding what Stevens said, Brady material that would help the defense under Brady v. Maryland, seminal case. So it is unusual, and it's so ironic if you think about it, because the whole defense side of this case is agency misconduct in the standoff, and then you end up with government lawyer misconduct in the courtroom. It's quite amazing.
So, Stephen, help us understand, why was this evidence, which reportedly is about federal snipers' positions as well as surveillance cameras, why was that evidence withheld?
It's a good question, and I don't know if we really know the answer. I mean, clearly it was the kind of information that should have been turned over to the defense. It's not the usual thing for prosecutors to not to disclose this kind of evidence, but it does happen, as we heard earlier. It's happened in other cases as well. It was a risk, and it didn't pay off for the prosecutors. Obviously, they've been caught, and now it's going to be up to the judge in January to decide whether there'll even be a retrial in this case.
Right, and you mentioned that because Judge Navarro has scheduled a January 8th hearing for arguments on whether the case should be dismissed with prejudice. So, Doug, explain what that would mean.
Well, if it's dismissed with prejudice, which is a sanction that the judge can impose, then the case cannot be tried again. That is a somewhat drastic remedy. You don't always see that, and I'm not necessarily confident in predicting that'll be happening. But I want to put a slightly finer point on the pencil of what Stephen was saying, and he's right. But think about it. One scenario is that the agents did not turn over the material to the government lawyers, okay? You had Bureau of Land Management agents, National Park Service agents. Those agencies don't deal with federal prosecutors as often as DEA, FBI, for example. So if the agents didn't turn it over, I think that'll be different in front of the court, as opposed to the government lawyers got it and they didn't turn it over. The judge, however, has already ruled that it was willful, implying that the government did have it. But at the January 8th hearing, they're going to flesh that out a lot more.
So, Stephen, do you think that Attorney General Sessions' investigation will help us better understand who it was that didn't turn over the evidence? And do you see this case going to a second trial, and should it?
Right. Well, Attorney General Sessions getting other people involved may help get to the bottom of this. I don't really think having a discovery expert involved necessarily will help, because I think the people involved know what the discovery rules are about turning over evidence. But it might help to get somebody with a fresh perspective, not as close to the case involved. As to whether there will be a retrial, I agree with Doug. It's an extraordinary remedy under situations like this for the court to bar a retrial. retrial, but not outside of the line here, because as Doug said, the court did find that the misconduct here was willful. The Supreme Court has said that when there is bad faith, quote unquote, involved in prosecutorial misconduct, then it can be the case that the trial judge has discretion to say there will be no retrial, and that broad discretion by the trial court is usually given a lot of deference on appeal.
Yeah, well, the Bundy trio, they have been in jail waiting for this, so we'll see what happens. Doug Burns, Stephen Mulroy, nice to see you.
My pleasure.
Thank you. Thank you.